Hey guys. So I wanted to just catch up with the Darrin Henson case, and I also got something updated on both the Friedman and Flores case, the estate of Travis Flores case against Friedman and his firm, and Steve Sarowitz and the Wayfarer Foundation lawsuit against Celeste Smith. So I'll be doing a couple of videos just to update on all of those cases. So we're going to look at the Darrin Henson one, just to catch everyone up to where we are right now. So Darrin Henson filed his lawsuit. Originally, it was against Sony Music Holdings, and it was filed in Georgia. Now he has voluntarily dismissed that case so he could refile his complaint in California against Sony Music Entertainment, so a different branch of Sony, along with Richmond Street Productions, who are the LLC that was set up to, for the Deadpool and Wolverine movie. He's also going after Epic Games, who are the kind of parent company of Fortnite. Lance Bass, who is one of the members of NSYNC, and Nick Pauli, who was the dancer, the dance pool character in Deadpool and Wolverine, who did his dance in the opening sequence. So that's where we are. Now, because he has dismissed his claim against Sony Music Holdings, they have filed rather, I think, slightly on the petty side here, but they have filed seeking attorney's fees, costs, expenses, etc., etc. Now, I can't imagine that their claim is going to be much at all, because they never even responded to his complaint. They never filed a motion to dismiss. They never even answered it. There still would have been some work that would have been done, and there was mediation as well. But, honestly, I'm not sure that it is necessary to do this, because there would be so little to recover. So it does feel just petty. But nonetheless, so they have filed it. So let's go through it. Okay, so defendant Sony Music Holdings files this response to plaintiff's notice of voluntary dismissal, opposition to plaintiff's motion for leave to file an amended complaint and transfer case, and motion for excess costs, expenses, and attorney's fees pursuant to U.S. Code 28, Section 1927. Although plaintiff has now, finally, voluntarily dismissed SMHI, that dismissal confirms the central premise of SMHI's position throughout this litigation, that SMHI was not the proper defendant. Because plaintiff still refuses to dismiss this case, the voluntary dismissal does not moot plaintiff's still pending motion for leave, nor does it deprive this court of jurisdiction to resolve SMHI's instant request for attorney's fees and sanctions arising from plaintiff's unreasonable multiplication of these proceedings. So, introduction. This case should never have been filed, and at most should have ended weeks ago. Plaintiff acknowledged that the only named defendant, SMHI, was not the proper defendant. He has omitted SMHI entirely from his proposed amended complaint and has now filed the lawsuit he actually wished to pursue in the Central District of California against different defendants. I mean, that's a bit of wordplay there. It is not beyond the realm to say, I mean, look at these are the two differences between the Sony branches, right? One is called Sony Music Holdings Inc., and the other one is called Sony Music Entertainment, right? And it is not unreasonable for someone to get confused over which one is the right one. So I just think this is really petty. Okay. Plaintiff also represented to this court that SMHI should not be required to answer the operative complaint, and assured the court that plaintiff would seek no adverse action against SMHI, yet plaintiff refused repeated requests to voluntarily dismiss SMHI. Instead, for months, plaintiff required SMHI to continue defending a lawsuit. Hadn't actually done any defense, by the way. Instead, for months, plaintiff required SMHI to continue defending a lawsuit plaintiff had already effectively abandoned to impose an improper motion for leave that seeks to transform this Georgia declaratory judgment action into an entirely different California copyright infringement action, and to incur substantial attorney's fees responding to litigation that plaintiff ultimately conceded should never have proceeded against SMI. Plaintiff finally filed a Rule 41A 1AI notice of voluntary dismissal late the night before SMHI's response to the complaint was due on July 9th, 2026. But plaintiff dismissed SMHI, only SMHI, not the action. Plaintiff deliberately left the Doe defendants in the case while leaving pending his motion for leave to amend and transfer. As a result, there is now no remaining party with any incentive or obligation to oppose plaintiff's procedurally improper motion for leave. Unless SMHI responds notwithstanding its dismissal, plaintiff's motion would effectively proceed unopposed, despite seeking relief that exceeds the scope of Rule 15, and despite plaintiff having already filed the very lawsuit he seeks leave to create. Plaintiff's procedural maneuver therefore has required SMHI to continue participating in this litigation to protect the integrity of the proceedings and to prevent plaintiff from obtaining relief that no remaining defendant is positioned to contest. Accordingly, this court should first determine that plaintiff's counsel unreasonably and vexatiously multiplied these proceedings within the meaning of U.S. Code 28, Section 1927, and then deny plaintiff's motion for leave because Rule 15 does not authorize replacing one lawsuit with another, particularly one that plaintiff has admitted he has no interest in pursuing in this forum. I'm really confused as to what they're arguing about here. Might have to look through the docket. Okay. An award of excess costs, expenses, and attorney's fees under U.S. Code 28, Section 1927 is warranted. Plaintiff's belated notice of voluntary dismissal resolved the merits of plaintiff's claims against SMHI, but it did not erase the unnecessary proceedings that preceded the dismissal or divest this court of authority to address the consequences of those proceedings. Section 1927 provides that any attorney who so multiplies the proceedings in any case unreasonably and vexatiously may be required personally to satisfy the excess costs, expenses, and attorney's fees reasonably incurred because of such conduct. Although the statute is penal in nature and is therefore strictly construed, the 11th Circuit has held that sanctions are appropriate where an attorney engages in objectively unreasonable conduct that multiplies proceedings and causes an opposing party to incur unnecessary litigation expenses. Okay. You know what? I'm going to have a look at this because I don't get their issue here. Okay, so at the bottom, because I'm doing it in descending order, right? So at the bottom, you've got the complaint. Filed by Darrin Henson. Then the certificate of interested persons and corporate disclosure statement by Darrin Henson. Then Darrin Henson has filed the electronic summons issued to Sony Music Holdings. Then there's an AO Form 121 forwarded to the registrar. That is from Darrin Henson. There's an entry from the clerks. There's 2 entries from the clerks, actually. And then there's an order, a notice of court instructions from the judge. Then Darrin Henson has executed the return of service. And then Sony have filed a motion for extension of time to file an answer. Darrin Henson has then responded to in opposition to the motion for extension of time, and then Sony have filed a response in response to the opposition to their motion requesting extension of time. Now Sony were granted their extension, and then we have a notice of appearance from the Sony attorneys. And then a joint motion to refer to non-binding ADR, so that's alternative dispute resolution, and a stay of proceedings. And then there's an order because they've been ordered to do mediation, so they are then everything is put on hold for the mediation. Right. Another order, granting the parties to refer the case to non-binding ADR process and stay proceedings. And then we get this other guy's is like Darrin Henson allegedly he must have sought some very brief legal advice from another attorney before, retaining the attorney he has currently on notice. But and this attorney is basically filed a notice of attorney's lien. He's saying, look, Darrin Henson owes me money. If he's awarded anything, I want you to hold my money, and before you give him money, because as part of settlements, the settlements don't go to so if Darrin Henson wins, the money is not going to go straight into his bank account from whoever he is awarded any money from. It is going to go through the accounts, the attorney accounts. That's what we do in the UK as well. They go through solicitors' accounts, right? Where the attorneys for, say, Sony lose, right? The attorneys for Sony will send money to their attorneys. Their attorneys will then send money to Darrin Henson's attorneys, and any fees, etc., anything that's owed is deducted before what's left is sent to Darrin Henson, and that's how that all works. And this lien is basic from James Walker is basically saying he owes me money. When you receive money, any damages for Darrin Henson, and you're deducting your fees, make sure you deduct this amount because he owes it to me before you send it to him. So it's effectively a charge. Darrin Henson has, again, that's nothing to do with Sony though. Darrin Henson objected to that. Then there was a reply brief from so Darrin Henson filed an objection and motion to strike and dismiss the lien. There was an opposition from James Walker, and then the reply brief from Darrin Henson. All nothing to do with Sony. And then James Walker had to refile something else about his lien. There was a problem with it, and he had to refile. That's it, because he didn't. Yeah, what happened? I knew there was something. Right, I can see it now. So what happened there is that he didn't seek leave from the court. He didn't seek permission, effectively, from the court to file his motion for notice of lien. So he had to then basically do it all again and say, as a sir reply. So he did. That was on June 26th. On the same day, Darrin Henson filed leave to amend his complaint and request for the transfer to Western Division. Yeah. Then he filed a notice of related case. So he's filed in California, and he's saying, Judge, this case is in California. And then on July the 8th, he has filed a notice of voluntary dismissal without prejudice. Now, here is the notice of voluntary dismissal, right? And this is where I'm a bit confused, like with Sony Music Holdings, like, what is your complaint? And they're saying, well, it leaves open claims against us. It doesn't. It doesn't, because the wording is, come now, plaintiff Darrin Henson, by and through undersigned counsel and pursuant to Federal Rule of Civil Procedure 41A1A1, hereby voluntarily dismisses all claims in this action against defendant Sony Music Holdings without prejudice. The only moan they could have is that it is not done on a with prejudice basis, so that he cannot, to prevent him refiling against them in the future. But I mean, it even goes as far as to say the dismissal only applies to defendant Sony Music Holdings Inc. and does not affect the claims against any other remaining defendants. Each party shall bear its own costs and attorney's fees. So that's what they're saying there, is like, well, it basically the case is left open. And that may be what Sony are like, well, hold on, you haven't withdrawn the complaint entirely here in Georgia. But, I mean, it was approved. The case is terminated. We'll continue reading, but I'm just like, want to go through the docket and see what has actually happened here. And have they got grounds for the arguments they're making? Okay. The 11th Circuit generally requires 3 elements. 1. Unreasonable and vexatious conduct. 2. Multiplication of the proceedings. And 3. A financial nexus between the conduct and the excess fees incurred. Those requirements are satisfied here. Plaintiff's notice of voluntary dismissal does not moot SMHI's motion under U.S. Code 28, Section 1927. Plaintiff's notice of voluntary dismissal pursuant to Rule 41A1A1 resolves only the merits of plaintiff's claims against SMHI. It does not divest this court of jurisdiction to determine SMHI's request for excess costs, expenses, and attorney's fees under U.S. Code 28, Section 1927, which presents a collateral issue independent of the merits of plaintiff's claims. The Supreme Court Circuit have long recognized that sanctions and attorney's fees proceedings are collateral to the underlying merits and therefore survive the termination of the principal action. Okay, so what they're saying is, look, yes, he's dismissed us from the case on a voluntary basis. However, we are still entitled to bring this action. Here, the case does not involve a Rule 11 motion or a case that has been completely dismissed. Instead, although SMHI has just been voluntarily dismissed late in the night on July 8th, 2026, the case is still pending before this court, and SMHI is requesting its excess expenses pursuant to U.S. Code 28, Section 1927. Indeed, plaintiff's notice of voluntary dismissal underscores rather than undermines the basis for SMHI's request. Throughout this litigation, counsel for SME, Sony Music Entertainment that is, consistently maintained that SMHI was not the proper defendant based on publicly available information and repeatedly requested that plaintiff voluntarily dismiss the claims asserted against SMHI. Plaintiff declined to do so. Instead, plaintiff filed a motion for leave to amend a notice of related case and an emergency motion seeking to relieve SMHI of any obligation to respond to a complaint that plaintiff simultaneously acknowledged he no longer intended to pursue. Only after requiring SMHI to prepare the present motion did plaintiff voluntarily dismiss SMHI. The notice, therefore, resolves only one aspect of this dispute. It confirms that plaintiff ultimately abandoned the claims asserted against SMHI. It does not resolve whether plaintiff's counsel unreasonably and vexatiously multiplied these proceedings by maintaining litigation against SMHI after acknowledging that SMHI was not the proper defendant, nor does it compensate SMHI for the excess costs and attorney's fees incurred as a result of that conduct. Nor does plaintiff's unilateral statement in the notice that each party shall bear its own costs and attorney's fees alter that conclusion. A Rule 41A1A1 notice may voluntarily dismiss claims against the defendant, but it cannot unilaterally adjudicate or extinguish a defendant's independent statutory entitlement to seek sanctions or attorney's fees on collateral grounds. Whether plaintiff's counsel is liable under Section 1927 remains a question for the court and is not resolved by plaintiff's unilateral characterization in the dismissal. Accordingly, plaintiff's voluntary dismissal does not moot SMHI's motion for excess costs, expenses, and attorney's fees pursuant to U.S. Code 28, Section 1927. Rule 41A does not codify any policy that the plaintiff's right to one free dismissal also secures the right to file baseless papers. The court therefore retains jurisdiction to determine that collateral issue. Plaintiff's counsel pursued claims against SMHI without a reasonable factual basis. This is not a case in which plaintiff simply named the wrong defendant despite exercising reasonable diligence. For more than a year before filing suit, plaintiff's counsel communicated exclusively with SME concerning plaintiff's claims. Plaintiff's own sworn declaration confirms that Attorney Dobbins represented plaintiff beginning in September 2025, resumed negotiations on plaintiff's behalf, and ultimately filed this action on March 27, 2026. Representatives for SME repeatedly informed plaintiff's counsel that SMHI has never claimed an interest in the choreography at issue. The SME is the parent company of Zomba Recording, the entity that owns the relevant copyright, and SME is the licensor on the relevant licenses pertaining to the choreography. Plaintiff's counsel was repeatedly advised that SME and SMHI are separate legal entities, and that's an important distinction to make, because yes, we are basically going from one branch of Sony to another branch of Sony, but they are separate and distinct legal entities, so you have to sue the right one. You can't just substitute one for the other. Plaintiff was also advised that personal jurisdiction over SME does not exist in Georgia. Despite these communications with SME, plaintiff elected to file suit against SMHI in the Northern District of Georgia. At the time this suit was filed, publicly available corporate records confirmed that SMHI and SME were distinct legal entities. Rather than identify any evidence establishing that SMHI owned, licensed, or exploited the choreography at issue, plaintiff instead relied upon a theory that SME and SMHI were effectively the same entity because a different entity, Sony Music Entertainment Inc., had changed its corporate name to Sony Music Holdings Inc. in 2009. I mean, if you're going to give yourself similar bloody names, then you know. Okay. Indeed, plaintiff affirmatively presented that theory to this court in opposing SMHI's motion for an extension of time, arguing that defendant's position that SMHI and SME were separate entities was entirely false, and asserting that SME has been doing business in Georgia as Sony Music Holdings Inc. Plaintiff has now unequivocally abandoned that factual position. Can we just go back, right, just to read this, yeah? Just to make some sense of this, right? And they themselves had basically said, right, okay, let's just... So, plaintiff relied upon a theory that SME and SMHI were effectively the same entity because a different entity, right? So SME stands for Sony Music Entertainment. But they're saying, well, we had a different entity called Sony Music Entertainment Inc. And they changed their name to Sony Music Holdings. But this Sony Music Entertainment is not the same as Sony Music Entertainment Inc. And the fact that, you know, Sony Music Holdings used to be Sony Music Entertainment Inc., you know, well, he should have known better. Mental gymnastics, right? When you have basically, you've got a company called Sony Music Entertainment. You have an entity called Sony Music Entertainment. You have another entity called Sony Music Entertainment Inc. And one of them changes their name to Sony Music Holdings Inc. And the only difference between them is Inc., which most people, like, when I refer to Sony Music Holdings, I don't use the Inc. bit. But it's just, it's absolutely ridiculous that people are not going to get fucking confused over that. You know, like, it's not, it is, in my opinion, that is not a wildly unreasonable stance for Henson to have taken. If the name, if Sony Music Holdings Inc., if they weren't originally Sony Music Entertainment Inc., they were, say, Sony Dance like Sony Dance Entertainment Inc., then yeah, it's a completely different entity. You know, the name is not as similar. But this is a fucking copyright infringement issue, and you know, they are being sued for copyright infringement, and they have, you know, the balls to then say, well, you shouldn't have got confused over our, you know, incredibly similar names. You should have known the difference. Just rubbish. Now, yeah, there is an argument to say an attorney who does their due diligence should have been able to pick up on that, right? I've just picked up on that. But, you know, human error and everything, but I mean, the names are so wildly identical that, you know, there is obvious wiggle room then for mistakes to be made. And when you run your various entities in this manner, when you operate in this manner, then I think you have to kind of take it on the chin a little bit that, you know, if a mistake's made, then maybe you should have done better at separating out. Okay, now that's my soapbox moment. Plaintiff's motion for leave to amend proposed amended complaint, notice of related case, and subsequent California action all now concede that SMHI is not the proper defendant. Plaintiff omitted SMHI entirely from the proposed amended complaint, substituted SME and additional defendants, and filed those claims as a separate action in the Central District of California. Consequently, plaintiff's present litigation position cannot be reconciled with the factual premise upon which this lawsuit was originally filed. And I'll tell you now why Henson has left open the Georgia complaint. Because at the moment, right, he's saying take Sony out. I'm gonna voluntarily dismiss Sony Music Holdings, right? But I'm gonna leave the case itself open because there are does 1 through 10, right? So he has the option of coming back and amending in Georgia and naming any does potentially. He's still doing discovery. So there could be things that he learns. And to save him having to refile a whole new complaint, he is just leaving a complaint that only has doe defendants pending that he can that he can close later. He can withdraw it later on if it turns out he does not need it. But if it turns out that there are defendants that can be added, then all he has to do is amend the complaint instead of refiling altogether. It's giving him less work. I genuinely don't see the issue in what Sony are complaining about here, in the fact that he's left the complaint open. I think that is actually sensible. It's less work, and it's the docket is already open and assigned to a judge. I really don't see the issue here. They got what they wanted, which was to be voluntarily dismissed. But the action now that he has brought before California is, it's related, but he's brought it before California because the defendants he's added to that, the jurisdiction over them is in California. It makes sense. So, but he's keeping the Georgia action open in case any does turn into actual defendants who and where the jurisdiction of Georgia makes sense. Okay. Consequently, plaintiff's present litigation position cannot be reconciled with the factual premise upon which this lawsuit was originally filed. This unexplained reversal is significant. Section 1927 does not require proof of subjective bad faith, but it does require conduct that, viewed objectively, falls outside the obligations of a reasonable attorney. Here, plaintiff's counsel first affirmatively represented that SMHI and SME were effectively the same entity in order to justify maintaining this action against SMHI in Georgia, while publicly available records showed otherwise. Plaintiff's counsel refused to accept SME's repeated representations about its ownership of the copyright at issue and its licensing activity and SMHI's lack of any involvement. After forcing SMHI to litigate this case, they haven't done anything other than request, delays and extensions. After forcing SMHI to litigate this case, including preparing a motion to dismiss and an opposition to plaintiff's improper leave to amend and transfer, plaintiff now affirmatively concedes that he was wrong and SMHI is not the proper defendant, and that consistent with SME's representation since before the suit was brought, SME is the proper defendant and this court is not the proper forum. Indeed, plaintiff has now filed his complaint in the U.S. District Court for the Central District of California, affirming in relevant part, Sony Music Entertainment is a Delaware general partnership with its principal place of business at blah. SME does business in California at blah. On information and belief, SME was originally formed in 2004 under the name BSO, and later that year became Sony BMG Music Entertainment, which was a joint venture between Sony Corporation of America and Bertelsmann AG from about March 2004 until about October 2008, and the same was renamed SME effective December 31st, 2008. On information and belief, SME gained ownership of the Zomba Group, the original owner of the promotional video created for the musical work Bye Bye Bye, around this time when Sony Corporation of America purchased Bertelsmann's 50% stake in the joint venture. Bertelsmann purchased the Zomba Group in 2002. This acquisition resulted in SME owning the rights in and to the music work Bye 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 and its related promotional video. The availability of publicly accessible corporate records before suit was filed and counsel's communications exclusively with SME for more than a year prior to filing suit strongly supports the conclusion that the claims against SMHI lacked an objectively reasonable factual basis, or at the very least that counsel acted with objective recklessness in continuing to prosecute these claims after their factual premise had been abandoned, in part to avoid losing his preferred forum, which he now concedes lacks jurisdiction over any of the newly named defendants. At a minimum, the record demonstrates that plaintiff's counsel lacked an objectively reasonable factual basis for continuing to maintain claims against SMHI, whether that resulted from an inadequate pre-suit investigation, an unreasonable interpretation of publicly available corporate records, or the continued prosecution of claims after abandoning the factual premise on which they were filed. The result is the same. SMHI was required to defend claims that plaintiff now concedes should have never proceeded against it in a forum that lacked jurisdiction to hear this dispute. After acknowledging that SMHI was not the proper defendant, plaintiff's counsels continued to multiply these proceedings. Even assuming arguendo that the original filing resulted from an honest mistake, despite the pre-suit communications and available public records showing SMHI and SME are distinct entities, any such excuse ceased once plaintiff acknowledged that SMHI was not the proper defendant. Plaintiff's counsel repeatedly rejected SMHI's request to voluntarily dismiss the Georgia action, despite simultaneously representing that and had already filed the action he actually wished to litigate in California. Rather than dismissing this case, plaintiff insisted upon maintaining this action solely to obtain rulings concerning procedural matters and a collateral attorney's lien issue, thereby requiring SMHI to continue incurring unnecessary attorney's fees. Specifically, plaintiff omitted SMHI from the proposed amended complaint in this court, filed a new California action asserting those claims against different defendants, omitting SMHI, filed a notice of related case advising this court of that action, acknowledged that this court does not have jurisdiction over the newly named defendants, argued that SMHI should not be required to answer the operative complaint, and represented that plaintiff would not seek a default or any adverse action against SMHI if it declined to respond. Those filings leave no genuine dispute that plaintiff had abandoned any claim against SMHI, yet plaintiff refused repeated requests to voluntarily dismiss the Georgia action. By doing so, plaintiff has required SMHI to respond to claims plaintiff himself no longer intends to pursue and respond to a motion for leave seeking to transform this lawsuit into an entirely different action. That conduct constitutes precisely the type of unreasonable multiplication of proceedings that Section 1927 was enacted to prevent. This is not merely an unsuccessful legal position, it is the continued prosecution of a lawsuit against the only named defendant after plaintiff acknowledged that this defendant should no longer be part of the case and that jurisdiction over the parties and claims plaintiff truly intends to pursue is elsewhere. I mean, I suppose the one question I do have out of all of this is, if it was as simple as, well, we're never the right defendants, and they've been talking for more than a year already, we're not the right defendants, you need to go to our other entity, Sony Music Entertainment, we're not the same, and the jurisdiction is all wrong. If they've already had all of those discussions, then why did they, instead of just putting all that down in a motion to dismiss, why did they then file an extension of time, motion for an extension of time to answer or otherwise respond to the complaint? If they had that argument ready to go for more than a year, then why did they need an extension? Right? And it wasn't, just one extension, right? There was initially an extension from the 22nd of April to May the 22nd. Then there was a further extension, and eventually, the whole thing was all extended till the 9th of July. That's a substantial amount of time. That's like 3.5 months. Because the lawsuit was filed on March 27th. And their response was due April 22nd. Well, in the end, they got to a point where their response wasn't due until July the 9th. That's quite some time. Why do you need all that time if your argument, you could have put all of this down in a motion to dismiss or whatever, and you would have been more justified in requesting fees because you had to file a motion to dismiss. This is just... I get what they're saying, but also this is bullshit. And petty bullshit at that. Right. Okay, let's continue. Okay, plaintiff's conduct directly caused SMHI to incur excess litigation and expenses. No, I don't agree with that. As I just said, you asked for all these extensions, you went to mediation, you could have filed your point in a motion to dismiss. And then maybe you could have avoided the mediation. Section 192 requires a nexus between the amount claimed as a sanction and the sanctionable conduct itself. Here there is a direct causal relationship between plaintiff's conduct and the fees incurred by SMHI. Plaintiff's refusal to dismiss SMHI did more than require SMHI to continue defending abandoned claims. It also compelled SMHI to oppose plaintiff's improper motion for leave because plaintiff's dismissal strategy otherwise would have left no remaining party positioned to challenge the requested relief. Had plaintiff simply voluntarily dismissed this action upon determining that SMHI was not the proper defendant and that it intended to pursue its claims in a different forum, SMHI would not have been required to analyse plaintiff's proposed amended complaint, prepare and file this combined response to voluntary dismissal, response in opposition to motion for leave, and motion for attorney's fees, address plaintiff's attempt to convert this declaratory judgment action into an entirely different California copyright infringement action, or continue defending a lawsuit that plaintiff has already superseded by filing a separate federal action. Those expenses were not the ordinary cost of defending disputed claims. They resulted solely from plaintiff's strategic decision to maintain litigation against SMHI after conceding it was going to litigate against different parties elsewhere. Okay. I mean, okay. So they did not have to go through his proposed amended complaint because they were left off it. They weren't included on the proposed amended complaint. And actually, in the motion for leave to file the amended complaint, Henson specifically said, where is it? As such, all independently known joint tortfeasors have been added as defendants. Allegations and claims have been asserted against each newly added defendant, and Sony Music Holdings, who was and is believed to be Sony Music Entertainment within Georgia, has been omitted. So in the motion for leave to file an amended complaint, he specifically said we are omitting Sony Music Holdings from this complaint. So they didn't really have to go through it. Okay. We continue. Accordingly, SMHI respectfully requests that the court find that plaintiff's counsel unreasonably and vexatiously multiplied these proceedings within the meaning of US Code 28, Section 1927, and award SMHI its excess costs, expenses, and reasonable attorney's fees incurred as a result of that conduct. At a minimum, those fees should include the expenses incurred in preparing and presenting the instant motion, so that's this motion, together with such additional proceedings as the court deems appropriate to determine the amount of that award. Plaintiff's voluntary dismissal confirms that SMHI was not the proper defendant. Plaintiff's notice of voluntary dismissal confirms what SMHI has consistently maintained throughout this litigation. Sony Music Holdings is not the proper defendant in this action. I disagree with that stance, and this is why. So yes, he's withdrawn them for now, okay, because there wouldn't, he's saying, well, there wouldn't be jurisdiction over Sony Music Holdings in California, right? That's why he brought the complaint against him in Georgia in the first place, because that's where the jurisdictional reach was. And he's saying, well, okay, for now I'm going to pursue Sony Music Entertainment. He has voluntarily dismissed Sony Music Holdings on a without prejudice basis, which means that he has the right to add them back later on. So it does not concede that they were not the proper defendant. He's saying for now the evidence does suggest that, another branch of Sony is the true and proper defendant. But if information comes to light down the road that actually you are and were the right defendant in the first place, I can add you back. That may be the second prong of why he's kept pending the Georgia action. It's not all because of Sony. Like I said, it will be because there are doe defendants listed in there, and if he is able to name any and Georgia has the jurisdiction, then he can just simply add them without having to fap around, and all this, all the various things. But also, yes, he can, in theory, also add Sony Music Holdings back. I don't want to drop any word out of the name because otherwise it could lead to mistakes. But yeah, he could in theory bring Sony Music Holdings back because there's going to be an argument. I mean, in fairness, both entities have Sony Music as the first two kind of parts of the name, and this does concern the musical side of things. So, and I can imagine this is probably feels like, when you ring a utility service or, you ring to sort out your Sky package or whatever, and they're like, you press, they go through, you get all the options, like press 1 for this, 2 for that, and 3 for the other. And then you press the one that sounds like the right option. And then you go through all security. You spend 15 minutes, kind of blaring out your problem after you've been waiting 15 minutes for someone to even answer the call because, their automated response is saying, we are taking high levels of calls at the moment, but we'll get to you as soon as possible. And as soon as possible is nearly an hour later, right? And then you start speaking to someone, you think, finally. And then they're like, I'm very sorry, I've got to transfer you to another department. And then you start the whole process again. And I can imagine that that's what this is probably feeling like for Darrin Henson. So no, I don't agree that he has conceded that they were not and never were they were not and they were never the right defendant. I'm saying I believe that for now he is saying that there may be stronger evidence that points to Sony Music Entertainment without the ink. But he is keeping, he has kept an option open if further evidence then says actually it was Sony Music Holdings. You were right. Okay. Although plaintiffs' Rule 41A1A1 notice renders moot SMHI's request for dismissal of the complaint, it also conclusively establishes that plaintiff ultimately abandoned the factual and legal premise upon which this lawsuit was filed. I don't agree with that. I don't like the way they're trying to frame this. Following the parties' unsuccessful mediation, plaintiff filed his motion for leave to file an amended complaint and transfer case in which plaintiff expressly represented that SMHI has been omitted from plaintiff's proposed amended complaint. Yes, because the jurisdiction of California would not be right. That is why that has happened. Consistent with that representation, plaintiff's proposed amended complaint jettisons his claims against SMHI, which sought a declaratory judgment that plaintiff was the copyright owner of the choreography at issue. In the proposed amended complaint, plaintiff seeks to proceed against a different corporate entity. Not that fucking different. SME and several other new defendants asserting entirely new causes of action for copyright infringement and related damages. Plaintiff admits he has no intention of pursuing this amended complaint in this court, as it inter alia admittedly lacks jurisdiction over any of the newly named defendants. Now, what I will say, right, is because I love how they leave this out. They're sort of sitting there and going, oh, well, we told him a year ago that it was a different Sony Music Entertainment, it was the one without the ink, etc., etc. So, but what Henson's motion for leave to file an amended complaint and to transfer the case a memorandum of law in support, which he filed on the 26th of June, where is it? Okay. So it does actually say that following the mediation, yes, here we are. So on June 22nd, 2026, the parties attended mediation. Sorry, I can't screen share because this is like a safe file. It's not, like an internet page. But I'm reading the actual proposed amended complaint and the leave to file it as well. So this is part of the leave to file the amended complaint that Darrin Henson filed, and it specifically says on June 22nd, 2026, the parties attended mediation and were again unable to reach an amicable resolution. At this time, not a year before, at this time, plaintiff also learned that Sony Music Entertainment will not agree to submit to this court's jurisdiction for the limited issue of ownership. Okay, so that's at that point. That is where they learned where that it is basically Sony Music Entertainment and not Sony Music Holdings. All right, we continue. On June 30th, 2026, plaintiff commenced an action and filed the identical complaint in the Central District of California against SME and the newly identified defendants. The following day, plaintiff filed a notice of related case in this court acknowledging his intention to pursue his new claims against the new defendants in California rather than continue litigating against SMHI in Georgia. Plaintiff therefore has not merely stated that SMHI is not the proper defendant. Plaintiff has acted upon that position by commencing a separate action, asserting new claims against different defendants in a different federal district. Until July 8th, 2026, however, plaintiff refused repeated requests to voluntarily dismiss this case against the sole named defendant, SMHI, thereby requiring SMHI to prepare the present motion and continue defending claims plaintiff had already acknowledged should not proceed against it. Only after compelling SMHI to incur those expenses did plaintiff file a notice of voluntary dismissal pursuant to Rule 41A1A1 just 2 hours before the day SMHI's response to the original complaint was due. The voluntary dismissal is significant, not merely because it terminates plaintiff's claims against SMHI, but because it confirms the correctness of SMHI's position throughout this litigation. From the outset, plaintiff's counsel was provided with publicly available records and information confirming that SMHI was not the entity claiming ownership of licensing or otherwise exploiting the choreography at issue, and repeatedly advised plaintiff's counsel that SME was a separate legal entity and the entity with whom plaintiff had been communicating concerning his claims since 2024, long before this lawsuit was filed. Plaintiff's voluntary dismissal represents an implicit acknowledgement that those representations were correct. Curiously, however, plaintiff did not dismiss this action. Plaintiff voluntarily dismissed only SMHI while expressly providing that dismissal does not affect the claims against any other remaining defendants. The only remaining defendants in this action are the unidentified Doe defendants named in the original complaint. Meanwhile, plaintiff has already filed the action he actually intends to pursue against identified defendants in the Central District of California. Plaintiff offers no explanation for maintaining this Georgia action solely against fictitious defendants, while simultaneously litigating the same underlying controversy against identified defendants elsewhere. Accordingly, although plaintiff's voluntary dismissal renders moot SMHI's request for dismissal of the complaint, it materially strengthens the remaining issues before the court. The voluntary dismissal of SMHI does not resolve plaintiff's still pending motion for leave to file an amended complaint and transfer case, nor does it deprive this court of jurisdiction to determine SMHI's request for excess costs, expenses, and attorney's fees under U.S. Code 28, Section 1927, both of which remain ripe for adjudication. Plaintiff's motion for leave should be denied. Rule 15 does not authorize a degree of the transformation here. Having voluntarily dismissed SMHI, plaintiff's request for leave to amend this action is even more procedurally anomalous. The only remaining defendants are unidentified Doe defendants, while plaintiff has already commenced the proposed action in California against the defendants he actually intends to pursue. Rule 15 provides no basis for converting a case against fictitious defendants into an entirely different lawsuit already pending elsewhere. Rule 15 reflects a liberal policy favouring amendment so that cases may be resolved on their merits. That policy, however, is not without limits. The decision whether to grant leave to amend remains committed to the sound discretion of the district court, and leave may properly be denied where the proposed amendment fundamentally alters the nature of the litigation, causes undue prejudice, or otherwise exceeds the permissible scope of Rule 15. Plaintiff's proposed pleading does not merely amend the operative complaint. It eliminates the sole defendant and the claims asserted against it. I wonder if they think that... I wonder if they're confused here and they think that Henson's proposed amended complaint is quite literally a complaint against them. not against them, but like, they're seeking to amend the same complaint here in Georgia that is against the defendants. But it doesn't. That's not what he's doing. Okay. Yes. So plaintiff's proposed pleading does not merely amend the operative complaint. It eliminates the sole defendant and the claims asserted against it, asserts no claims against that defendant, substitutes an entirely different group of defendants, replaces a declaratory judgment action with copyright infringement claims seeking damages, adds a jury demand, and seeks to litigate those claims in an entirely different federal district. In substance and effect, plaintiff seeks to replace one lawsuit with another. No, I'm not seeing that because they are the same facts. This is what you do when you amend a complaint. You sharpen it and to have incorrect information, to have correct information, correct causes of action, and correct defendants. I don't see what their complaint, their grumble is here. Federal courts have repeatedly recognized that Rule 15 does not authorize that degree of transformation. In Summit Office Park, the former Fifth Circuit explained that a pleading abandoning the original parties and asserting entirely new claims possesses the characteristics of a new lawsuit rather than an amended complaint. Likewise, in Sapphire, the Second Court held that leave to amend was properly denied when the proposed amendment would transform the case, in effect dismiss the original defendants and pursue a completely different claim, explaining that an amendment is improper when it introduces an entirely new claim both as to its substantive content and the identity of the persons against whom relief is sought. I mean, it sounds to me like Sony Music Holdings is saying, well, we've been telling them for ages, we're not the right defendants. They need to go after SME. And then as soon as he goes after SME, it's like, yeah, but you can't allow that as a whole new lawsuit. He's changed the defendants. He's changed the jurisdiction. It's like, what are you talking about? Like most people, well, most defendants, when they're dismissed, would be like, yeah, thank you for that. They'd take that win and fuck off. But no, not here. More recent decisions are to the same effect. Courts have held that when a proposed amendment abandons the existing litigation and instead asserts separate claims against different defendants, the proper course is commencement of a new civil action, not amendment of the existing complaint. As the court observed in Bay, where a proposed amendment missed the target so wide that it changes the defendants, the claims asserted and the relief requested, the proper procedural vehicle is a new lawsuit rather than an amended complaint. Similarly, Irabi concluded that an attempted amendment asserting a wholly new case against new defendants was not a proper amendment under Rule 15, but instead required commencement of a separate civil action. Plaintiffs' proposed pleading falls squarely within these authorities. The only defendant disappears, the only operative claim disappears, the requested declaratory relief disappears. In their place appear new defendants, new causes of action, new remedies, a jury demand, and a request to litigate in California. All the while asking this court to rule on an abandonment that the plaintiff has no interest in pursuing in this court, as he admits that this court lacks jurisdiction over these defendants. Instead, plaintiff himself has now filed precisely that lawsuit in the Central District of California. Having already commenced a separate action, plaintiff effectively acknowledges that the proposed pleading is not an amendment of this case, but an entirely different lawsuit that he does not intend to pursue here. There is nothing for the court to do here except dismiss the current lawsuit so that the plaintiff can pursue the California action. Once the plaintiff determined that SMHI was not the proper defendant, that additional defendants should be sued, that damages rather than declaratory relief should be sought, and that California was the proper forum, the federal rules supplied the appropriate procedural mechanism. Voluntarily dismiss this action and proceed with the newly filed California action. Plaintiff has already undertaken the latter. Rule 15 does not permit him to avoid the former. Once plaintiff alerted SMHI to his plan, SMHI repeatedly requested, to no avail, that plaintiff dismiss this action, relieve SMHI of the impending court deadlines, and pursue his new claims against the new defendants in a jurisdiction that he believed he had jurisdiction to hear the dispute. Plaintiff refused to do so, forcing SMHI to incur considerable fees given the court deadlines. Accordingly, plaintiff's motion for leave should be denied. The proper procedure was voluntary dismissal and filing of a new action. The federal rules already provide the appropriate procedural mechanism for the circumstances presented here. Once plaintiff determined that SMHI was not the proper defendant, that additional defendants should be sued, and that jurisdiction did not exist over them in this forum, that damages rather than declaratory relief should be sought, and that California was the appropriate forum, plaintiff's remedy was straightforward. Voluntarily dismiss this action pursuant to Rule 41A and commence a new action against the appropriate parties in the appropriate forum. And while plaintiff has commenced a new action in California, he has refused to dismiss this action. Plaintiff apparently wishes to preserve briefing on a collateral attorney's lien dispute in this court while transferring the remainder of the case to California. Whatever practical benefit plaintiff perceives in that approach, neither Rule 15 nor the court's limited jurisdiction authorizes maintaining an otherwise abandoned federal action for the purpose of preserving rulings or briefing on a collateral state law attorney's lien dispute. The perceived inconvenience of refiling that motion practice in another forum cannot justify requiring SMHI to continue litigating a lawsuit that plaintiff has already properly abandoned via a separate action. Plaintiff's motion for leave should be denied. Plaintiff's procedural maneuver has left no remaining party to oppose the motion for leave. Plaintiff's voluntary dismissal creates an unusual procedural posture. Having dismissed the only named defendant while leaving only unidentified defendants, plaintiff has effectively removed every party with a practical interest in opposing the motion for leave. Yet plaintiff continues to seek affirmative relief from this court through a motion that would fundamentally transform this case into an entirely different lawsuit already pending elsewhere. Unless SMHI responds notwithstanding its dismissal, plaintiff's motion for leave would effectively proceed unopposed. Rule 15 does not contemplate such a result, nor should plaintiff be permitted to engineer it by dismissing the only defendant capable of addressing the procedural impropriety of the requested amendment. Conclusion: plaintiff's voluntary dismissal of Sony Music Holdings confirms the central premise of SMHI's position throughout this litigation. SMHI was not the proper defendant, and plaintiff ultimately abandoned the claims asserted against it. That belated dismissal, however, neither validates plaintiff's procedural maneuvering under Rule 15, nor extinguishes the necessary proceedings plaintiff's counsel required SMHI to defend before finally dismissing it from this action. Plaintiff's pending motion for leave remains procedurally improper, and plaintiff's voluntary dismissal does not deprive this court of jurisdiction to determine SMHI's entitlement to excess costs, expenses, and attorney's fees under U.S. Code 28, Section 1927. Wherefore, defendant Sony Music Holdings respectfully request that the court 1. Acknowledge plaintiff's notice of voluntary dismissal as effective with respect to plaintiff's claims against Sony Music Holdings pursuant to Rule 41A 1A 1. 2. Deny plaintiff's motion for leave to file an amended complaint and transfer a case because the proposed pleading is not a proper amendment under Rule 15, but instead constitutes an entirely new lawsuit that plaintiff has already commenced in the Central District of California. 3. Determine that plaintiff's notice of voluntary dismissal does not moot SMHI's motion for excess costs, expenses, and attorney's fees pursuant to U.S. Code 28, Section 1927, and that this court retains jurisdiction to adjudicate that collateral issue. 4. Deny plaintiff's attempt to maintain this action against unidentified Doe defendants after voluntarily dismissing the only named defendant, dismiss the remaining claims without prejudice, and retain jurisdiction solely to resolve SMHI's motion for excess costs, expenses, and attorney's fees pursuant to U.S. Code 28, Section 1927, and any proceedings necessary to determine the amount of such award. Find that plaintiff's counsel unreasonably and vexatiously multiplied these proceedings within the meaning of U.S. Code 28, Section 1927 by pursuing and maintaining claims against SMHI without an objectively reasonable factual basis, and by continuing to litigate against SMHI after acknowledging that SMHI was not the proper defendant. Award SMHI its excess costs, expenses, and reasonable attorney's fees pursuant to U.S. Code 28, Section 1927 to be assessed against plaintiff's counsel in an amount determined by the court, including at a minimum the fees and expenses incurred in preparing and presenting the instant motion, and 7. Grant such other and further relief as the court deems just and proper. Okay, so I'm not going to go into any great detail because I talked at the various points I wanted to talk about, but I'm interested to see how Henson responds. I can see some of what they're saying, what Sony Music Holdings are saying. I can see that a little bit. But I can see a lot of problems with their arguments as well. So, yeah, I mean, they may get their costs back, though. That's a reality that might happen. I just don't anticipate them being, a lot in reality. But we shall see. All right, guys, let me know your thoughts, and I will be my next video will be on the Steve Zarowitz case, and then I will follow that up with the Travis Flores estate and Brian Friedman case. Thanks for listening, guys.